Hi everyone, in this week's video we'll be discussing dependent leave, time off for dependents under sections 57A and B of the Employment Rights Act. Most businesses will have been affected by these provisions at some point. They do apply to all employees irrespective of length of service, whether they work full or part-time and whether on a permanent, temporary or fixed-term basis. So this legislation provides a right for employees to take a reasonable amount of time off where it's necessary to do so in specific circumstances. So first of all, I'll just list out those different reasons. The first being to provide assistance if a dependent falls ill, gives birth, is injured or assaulted. Businesses often ask, is there a way that right can be restricted in any way? And I think the theme throughout this advice is that it can be very difficult to do so, particularly because of the protection that the legislation affords to employees. But importantly, the right is here to provide time off, is for time off to provide assistance. So it doesn't give employees the right to take time off to provide personal care for a dependent who may be ill, beyond the reasonable amount necessary to enable them to deal with the immediate crisis, and that's according to the Employment Appeals Tribunal. So you are providing assistance, but you are not personally providing care. I think if that was to happen, you would look at unpaid leave at the discretion of the employer, maybe using annual leave if necessary. The right also applies where it's necessary to make arrangements for the provision of care of a dependent who is ill or injured. Again, it doesn't necessarily enable the employee to take additional or ongoing time off to physically provide care for the dependent themselves, beyond that which is reasonable to make arrangements for the care. So we're talking about providing assistance, we're talking about making arrangements, we're not talking about spending significant amounts of time actually attending to the child. If the employee wants to undertake care themselves, then they may be expected to take other types of leave, as I've suggested. Now, the government guidance here states, if your child falls ill, you could take time off to go to the doctor and make care arrangements. Your employer may then ask you to take annual leave or parental leave if you want to look after your child for longer. The right also applies where it's necessary to take time off in consequence with the death of a dependent, and also to deal with the unexpected disruption, termination or breakdown of arrangements for the care of a dependent. There has been some litigation in this area. One concern from employers is that if, for example, a childminder is unable to look after a child at very short notice, it's very difficult to actually make arrangements for the care of the child in those circumstances. So dependent leave may have to be taken. But there is an interesting case, Royal Bank of Scotland and Harrison. The employee learned on 8th of December that the childminder would be unavailable on the 22nd of December. The bank argued that the disruption to the arrangements was not unexpected, so this cannot have arisen in an emergency because there were 14 days notice. The Employment Appeals Tribunal agreed. Unexpected does not necessarily involve a time element, and the employee is under a duty to try and make alternative arrangements, but if they can't do so, it will become necessary to take that time off. So that case is just a reminder really that whilst we have exceptions in the legislation and we read words such as providing assistance and dealing with an emergency, it doesn't extend to actual care. I think there is a wide element of discretion for employees in circumstances where they physically can't make those arrangements elsewhere. Now, I did say the legislation requires that the time off is necessary, and we look to the case of Qua and John Morrison solicitors here. Is it necessary for the specific employee to take time off to deal with that emergency or unexpected breakdown in arrangements? The Employment Appeals Tribunal in this case said factors we need to consider include the nature of the incident, the closeness of the relationship between employee and dependent, and the extent to which anyone else was available to help out. So we may have a debrief after the event where we ask employees whether in the future other arrangements could be made, other individuals could attend to the dependent. Nothing wrong with doing that, but we move on to consider more formal action, which we might be restricted from doing in those circumstances. The other area of challenge is what is a reasonable amount of time off, because the legislation says a reasonable amount of time can be taken. Surprise, surprise, there's nothing which states how much time is reasonable. And again, we're looking at the Qua and John Morrison solicitors case here. The section in the Employment Rights Act does not limit the amount of time which can be taken. It may be in the vast majority of the cases no more than a few hours or 1 or 2 days might be reasonable, but again, there may be circumstances where that extends beyond that time. It will depend on the nature of the incident and the employee's individual circumstances, and disruption or inconvenience caused to the employer's business should not be taken into account. So it's very much on the particular situation, on the circumstances of the employee and their dependent, and the operational needs of the employer cannot be relevant to a consideration of whether a certain period of time is reasonable or not. So the right only applies where an employee tells their employer as soon as reasonably practicable the reason for the absence and how long they expect to be away from work, unless it's not reasonably practicable to tell them at that point. For example, it may simply not be known. An employee who does not report within reasonably practicable timescales will lose the protection under the Act. Haven't actually come across any cases where that has happened, but bear in mind that we need to keep that under review. An employee cannot just be radio silent and then a few days later come back into work and say they've taken dependent leave. Now, the Employment Rights Act does not require employers to produce evidence of their need to take time off. I think on a sensible basis, it is reasonable to request evidence if we've got reasonable grounds to make that request, so we're avoiding any breach of trust and confidence, and we're not discriminatory or subjecting an employee to a detriment. I think we can ask for that evidence. And on the subject of detriment, the protection under the Act is against dismissal and also against suffering a detriment as a result of exercising this statutory right. So, for example, we could not threaten to take disciplinary action unless an employee could produce a hospital appointment card or something from the school that evidenced a breakdown in care arrangements. So an employee who is refused permission to take time off or who is subjected to a detriment may complain to an employment tribunal and may succeed with that claim and receive an award as a result. More importantly, an employee who is dismissed, if the reason is that they took or sought to take time off, if they are dismissed, then they have an unfair dismissal claim. And importantly, that is an automatic unfair dismissal claim, which means they do not need 2 years of service to bring that. The sensible option here is if an employer is considering dismissal, particularly if it relates to absence, separate out the absence on account of sickness or injury or for other reasons which we can act upon. Leave well alone in relation to dependent leave, even if we feel that time off may be excessive, unless we have clear evidence of a breach of the employee's reporting requirements, or if we can evidence that they may have been dishonest in taking some of that leave. This is a really tricky area to advise on. The biggest question I get is an employee is taking an excessive amount of time off. Can I do anything about it? And the issue is the protection the employee has and the difficulty in showing what is reasonable and what is not. I think meeting with the employee, trying to provide alternative options in the event of a future need, and looking at evidence on a case-by-case basis might hopefully limit the amount of time off being taken. If you do need any further advice on time off for dependents or anything else employment law related, please do visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.